Hello, I'm Rosemary Andolino, Commissioner of the City of Chicago Department of Aviation. Under the leadership of Mayor Richard M. Daley, the City of Chicago has become a world-class city, a global city. The Mayor has also set high expectations for us to conform to the highest ethical standards of performance. He has placed his trust in us to maintain a commitment to serve the public and to place their interests first. That is our commitment and our mandate as public servants. Personally, I consider it a privilege to serve the City of Chicago and its citizens. The following video provides an overview of the city's ethics standards and conduct for the Chicago Department of Aviation and the O'Hare Modernization Programs, city employees, as well as contractors and vendors that do business with us. As you will see in the video, the city's ethic ordinance, as established by the Chicago Board of Ethics, clearly defines guidelines with regards to gifts, employment of relatives, prohibited conduct, contract inducements, lobbyist regulations, restrictions on current and former city employees and officials, and limitation on campaign contributions. The Department of Aviation's ethics policies include additional guidelines, most notably its zero-gift policy, which will be explained further during the workshop presented in this video. Because the nuances of the ethics policy can sometimes appear complicated, this training video has been developed to be as clear and concise as possible. The workshop is intended to help you recognize potential ethics issues on your own and provide guidance on who to contact for expert advice. Our goal is to make our department's conduct completely transparent and to discourage and prevent conflicts of interest or even the appearance of a conflict of interest. On behalf of the City of Chicago and the Chicago Department of Aviation, I want to thank you for your continued hard work and commitment to maintaining the highest ethical standards. I trust you will find this video to be informative and enlightening, and I appreciate your close attention. Thank you.
I'm Steve Berlin, the Executive Director at the City's Board of Ethics. What I'd like to do at this point is I would like to show you our training video that was developed about a year ago specifically for vendors and contractors of the city. It lasts about 5 minutes. And then when that's over, we'll see if there's any questions. And if not, I'll move into the material topic by topic.
Hello, I'm Jamie Rhee, Chief Procurement Officer for the City of Chicago. Thank you for taking time to learn about doing business with the city. As a potential or current vendor, you should be aware of the rules and ordinances that govern the city's contracting processes. The procedures and regulations you will learn about in this video serve to ensure that the City of Chicago maintains a procurement process that is fair, transparent, and accessible. Thank you again for your interest in doing business with the city. We look forward to working with you in the future.
Hi, I'm Gene Honda. The important information that we cover here will help you to understand the ethics rules and to prepare to comply with them. The rules are pretty straightforward, so let's go through them one by one. Let's first talk about some of the rules on gifts. City law limits the gifts any person can give or offer to give to a city official, employee, contractor, or candidate for elected city office. The law says you can't give them any cash gift or any anonymous gift, and you can't give any gift based on a mutual understanding that the city employees or officials' actions or decisions will be affected in any way by your gift. The law also says you cannot give a gift to any city official or employee who can affect your city business, except for an occasional non-monetary gift of nominal value. And you cannot give more than $100 in gifts to such a city official or employee in a calendar year. However, any gift, no matter how nominal, which could create even an appearance of impropriety, is strongly discouraged. And by the way, the restrictions on gifts to city employees and officials also apply to their spouses and minor children. And some departments may prohibit their employees from accepting any gifts from vendors or would-be vendors. So be sure you know the department's rules too. City law also says that any contract obtained, entered into, or performed in violation of the ethics laws can be canceled by the city. So it's important for you to understand the ways in which not only your conduct, but the conduct of others can affect your ability to obtain and keep a city contract. First, if your business is wholly or partly owned by a city employee or elected official, city employees and elected officials cannot have financial interest in any contract, work, or business of the city. Essentially, this means that a city employee or elected official cannot have an ownership interest in any city contract if that interest has a cost or present value of $5,000 or more, or if that interest entitles the owner to receive more than $2,500 a year. These restrictions apply to appointed officials as well, unless the contract is wholly unrelated to what they do for the city. If an employee's or official's interest in any city contract exceeds these limits, the contract can be canceled by the city. Second, if you hire a city employee or official, city law prohibits that person from giving you advice or assistance on a city contract unless the advice is wholly unrelated to his or her city duties. Third, if you hire a former city employee or official, that person cannot assist you on a city contract if, while working for the city, he or she personally helped to formulate or supervise that contract. Nor can that person, for 1 year after leaving city service, assist you on any matters involving the city if, while with the city, he or she was personally and substantially involved in the same or similar matters. And if you employ or contract with a relative of a city official or employee to work on a city contract, the official or employee cannot oversee or supervise your city contracts. The city also has laws that regulate lobbying. If you lobby the city or hire a lobbyist to assist you in seeking a city contract, the person who lobbies must register with the city. And if you employ or retain an unregistered lobbyist, or hire a lobbyist on a contingency basis, you can be fined up to $2,000 a day. City law also limits the type and amount of campaign contributions that can be made to an elected official or candidate for elected city office. For example, cash contributions cannot exceed $250. Anonymous contributions, or those made in someone else's name, are unlawful. And there is also a $1,500 annual limit on the amount of money registered lobbyists and persons doing business or seeking to do business with the city or any of its sister agencies can contribute to any candidate or elected official of the city.
Hi, I'm Steve Berlin, the Acting Executive Director of the City of Chicago's Board of Ethics. Thanks for watching. If at any time, after watching this video or taking the online ethics training quiz that we have for vendors, you have any questions, please call the Board of Ethics at 744-9660 or check our website at cityofchicago.org. Thank you. Thanks. That was taped last fall, and my title has changed, but that's okay. The substance of that video remains current. Does anybody have questions about matters that were raised in the video at all? Okay, what I'd like to do is cover a couple of key topics here. The first one is, just want to remind everybody what Ellen had said and underscore what Ellen had said before, which is gifts. I will say that the Board of Ethics receives more calls on gifts than any other substantive topic in the ethics ordinance aside from ethics forms each year. And there's a reason for that, and that's because the world revolves, or some of the business world revolves around gift giving. Now that is not, or should not be, an issue for anybody in this room, because as Ellen said, the Department of Aviation/OMP has issued a no-gift policy. And there are several departments in city service that has that. And in fact, as the video mentions, there is a particular provision of the ethics ordinance that authorizes any city department to have rules and to adopt rules or regulations that are stricter than what's contained in this ordinance. The ethics ordinance can be looked at as a floor, not a ceiling, okay? In fact, what we say is that the ethics ordinance really is the floor, and if you really want the ceiling, what you should do is comply with the spirit of the law as well. It's a law, but it also has aspirations. One of the things that the department has done here is to add that ceiling. In other words, there shall be no gifts at all. So keep that in mind. If there are ever questions about interpretation of that policy, Ellen is the person to contact, and if the department has questions, they can seek advice from us. But it makes it easy for all of you. No gifts. And that is not the case for other city officials and city employees, which is why we have so many questions. But for you, it is easy. So just keep that in mind. No gifts offered, no gifts accepted. What I want to talk about briefly also is something that the video mentions, which is employment of relatives, or nepotism. We get quite a few questions about employment of relatives every year from city officials and city employees. There are two key provisions that everybody should be aware of. The first one really deals with internal city matters, and it says that no city official or city employee can supervise a relative or domestic partner of theirs on their city job. And that means that if you have one relative who's a deputy commissioner or an assistant commissioner, and you have another relative who works in the same city department that is a laborer or a foreman, for example, and they're in the same chain of command, it's not an automatic violation, but it means that the person in the supervisory position would have to delegate all employment-related authority to another person in the department who is not a relative of the other individual, the foreman, the laborer, etc. Sometimes because of the size of a city bureau, that's impossible, and there has to be a transfer that's made. But what it means then is that the person in the supervisory position could not make daily work assignments with respect to his or her relative, could not sign off or approve vacation time, raises, promotions, sick time, anything that would constitute employment supervision. That would have to be very carefully delegated to somebody else in the department who is not a relative of the other person. And if a department cannot make that accommodation, then there would have to be a transfer of either of those employees to another bureau or to another department. That's what the law requires. The second provision in the nepotism section of the law is really the one that deals with vendors. And what that says is that no city official or city employee may exercise contract management authority with respect to any city contract that is being performed by a company or a person that employs one of their relatives or domestic partners, or that contracts with one of their relatives or domestic partners. Now that sounds complicated, but what it really means is that city officials and city employees cannot work on contracts with companies that hire their brothers, their sisters, their sons, their daughters, their aunts, their uncles. That's really what it means. So it means that you'd have to have a screening arrangement. What's known in the trade as an ethical screening arrangement, whereby the city employee is screened off from any work with respect to that contractor or that vendor. That's what the law requires. I want to talk a little bit about relationships with elected officials of the city and loans to city officials and city employees. This is a provision in the law. It's section 111. I'm not going to bore you too much with section numbers, which are of interest to me because I'm a lawyer and I'm a geek. But as far as you're all concerned, what it means is that there cannot be any loans from any city contractor or any city vendor to any city official or city employee, or to their spouse or to their domestic partner, or to any business which the employee or the official or the spouse or domestic partner owns. In other words, no sweetheart loan deals between city people, city officials and city employees and their outside companies, and city vendors. The exception here is if the city vendor is a financial lending institution, i.e. a bank. Luckily, there still are some banks that are in business, and some of them actually do business with the city. Chase, Northern Trust, Bank of America, they come to mind. It means that if you're a city official or a city employee, you can have your mortgage on your house with Northern Trust. You can receive an outside business loan from Chase. But what it means for those of you who are vendors or contractors, unless you're a bank, and I don't think anybody sitting in this room is a bank or a financial lending institution, you cannot make loans to any city official or city employee, regardless of amount, regardless of interest rate. Otherwise, you'd be in violation of the governmental ethics ordinance. Or either to the employee or to the official or to any business which either they or their spouse or domestic partners own. So no loans between city vendors and city employees, city officials, their spouses, and their domestic partners. That's what that provision means. The exception is for financial lending institutions and market rate loans. So the other way that this applies is if any of your companies have a business relationship with an elected official. If they do, then your company would be in violation of the governmental ethics ordinance, because what the law says is that any person or any company who has a business relationship with an elected official, what does that mean? A business relationship means any contract or business dealing with an elected city official, any of the 53 elected city officials, the mayor, the clerk, the treasurer, or any of the 50 aldermen. Actually, currently we have 49 aldermen. We have a vacancy in the 26th ward. But with any elected official of the city, if your company is contractually obligated to pay an elected official or a business which he or she owns $2,500 or more in compensation a year, then you cannot be a city contractor. It means that, for example, your companies could not hire a law firm of which an alderman might be a partner. Because if you do, then you'd have to give up your city contract. That's really what it means. So those are two kind of quirky prohibitions in the governmental ethics ordinance. We don't get many questions about loans or about this business relationship aspect. They're very complicated in many ways, but they are on the books. And if there's ever a question about one of your companies hiring law firms of which city elected officials may be partners or of counsel, for example, or hiring companies that are affiliated with or potentially owned by city elected officials or their husbands or their wives or their domestic partners, pick up the phone, give my office a call. Don't take the chance that your city contract might be jeopardized. I want to talk a little bit about lobbyists and lobbying. Who is a lobbyist, and what are lobbyists required to do? What can they not do? A lobbyist, the city of Chicago defines lobbyist very broadly as any person who represents another, potentially an employee, an employer, or a client of theirs, to influence any city legislative or administrative action. Legislative action means anything that could be presented to the city council. A lot of things are presented to the city council. A lot of things that involve the Department of Aviation and OMP are presented to the city council. Those are legislative matters. What is an administrative matter? Basically, an administrative matter is any decision that's made by a city official or a city employee with respect to procurement matters, contract matters, matters involving concession agreements out at the airports, bond matters, real estate sales, real estate leases, real estate zoning matters, tax increment, basically any decision that's made by a city official or a city employee is an administrative matter. Well, what does that mean? What does it mean when your company comes in and meets with somebody from the Department of Aviation? Are they lobbying? The short answer is that if your company is seeking a city contract and is not responding to an already existing RFP, request for proposals, or RFQ, request for qualifications, then yes, your company is lobbying. What does that mean? If your company is lobbying, then what it needs to do, or somebody needs to do from your company, particularly the people who are interacting with the city folks, are going to have to call the Board of Ethics and register as a lobbyist so that they can continue to seek that contract. They can continue to meet as much as necessary with city officials and city employees and try to influence their judgments. There's nothing wrong with lobbying. There's nothing wrong with meeting with city officials and city employees and trying to influence their judgments. That's the way business is conducted, and that's the way business ought to be conducted. It just means that if you are, unless you're responding to an RFP or an RFQ, and you are trying to influence the city's judgments as to procurement matters, as to contract matters, not in terms of performing an existing contract, but in terms of seeking additional contracts or contract modifications, then you'll have to register as a lobbyist with the Board of Ethics, which means that you call us up, you fill out an annual registration form, you got to pay a $200 per year per lobbyist fee, and then every January 20th and every July 20th you file lobbying activity reports which show who you've lobbied, a brief description of the actions on which you've lobbied, and what gifts, if any, of course that would not apply here, but that does apply to lobbyists, what gifts, if any, you've given to city officials and city employees. So lobbyist basically means anybody, unless it's pursuant to an existing contract, anybody who meets with the city of Chicago or its officials or employees to try to influence policy matters, to try to procure a contract for which an RFP or RFQ is not already issued, or tries to influence the city's judgments as to potential changes in the municipal code.
I have a question.
Yes, please.
You said if the RFP is already issued, you don't have to go register.
That's correct. The question was, if the RFP or the RFQ has already been issued, then you do not have to register. And that is an activity that is carved out of the definition of a lobbyist. A person who is responding to an existing RFP or RFQ is not required to register as a lobbyist by that activity. The other exemption, which will not apply to people in this room, is that as a matter of policy, as a matter of law, not-for-profit organizations and their officers, their staff members, and their board members are not required to register as lobbyists either. If a not-for-profit has a, quote, hired gun, unquote, if they hire a law firm at the law firm's regular or even reduced rates to lobby on behalf of the city, then the law firm would still have to register. But a not-for-profit organization and its employees, its board members, its staff members, they are exempt from registration as a lobbyist. So not all cities have provisions like that. That's just the way the city of Chicago cuts it. So now, what are the obligations of city officials and city employees with respect to dealing with lobbyists? There really aren't any. Even if a person is not yet a registered lobbyist and you are a city official or city employee who's talking to that person and you spend 45 minutes talking to that person, neither of you are in violation of the law, because if the person's not yet registered and they have just engaged in lobbying activity, they have 5 days to register with the Board of Ethics. And likewise, if you're a city official or city employee, you are not prohibited from talking to somebody, even if they're lobbying you and they're not yet registered. You're not required to make them register. Whatever penalties there are for unregistered lobbying activity would ultimately be imposed upon the lobbyist, him or her or itself. And what it means is that any contract that is entered into based in part on unregistered lobbying activity is voidable by the city. The city could cancel the contract. And if a lobbyist, after receiving a series of certified mailings from my office, fails to register, in other words, blows us off, then the Board of Ethics has the authority to fine those people up to $2,000 per day. Frankly, those are pretty substantial fines. They could add up pretty quickly. But the key here is that if you're a city official or city employee, what we advise people, the best practice for you to do if you're a city person, is when you see somebody who's coming in and you suspect that they're lobbying you, just to say, look, I don't work for the Board of Ethics, but don't embarrass either of us. If you're lobbying, which you might be, just do us both a favor after you leave here this morning and call the Board of Ethics for advice and let them figure out, in other words, let my office figure out whether that person in fact engaged in lobbying, whether they should register. And we'll give the person a ruling. It's really as simple as that. So bottom line here is that if there's ever a question, again, like so many things, pick up the phone, don't be shy, give my office a call. So, yes, please.
If somebody's a vendor or distributor or manufacturer of a product and he calls a city employee and wants to present that product to the city, that would be considered lobbying?
That's a very good question. In fact, that's a question that comes up with a lot of the large line departments, such as aviation. And here's what we say. As a technical matter, yes, that is lobbying. But what we tell the city people and what we would tell the company is, for that first meeting, there's no reason for somebody to register in order to make that first meeting. But if the city's interested and they want to take it to the next level and they want to have a second or a third meeting, and ultimately it's going to lead to an RFP or an RFQ or maybe a sole source contract, at that point, once it gets taken to the next level, then the company ought to register as a lobbyist, or it ought to have its main city contact register as a lobbyist.
Now, if the city solicits that person and said, wants information about a product, does that person need to register, or is it that person basically just... The fact that the city solicits it doesn't actually make a legal difference, because the reasoning behind the lobbying provisions is transparency and that the public has a right to know who's dealing with the city. So the fact that the city solicits it wouldn't take it out of the lobbying restrictions. But again, though, the first meeting is one where both the city and the company are, as they say, doing the dance, and they're both seeing if there's a possibility of moving forward. If there's no possibility of moving forward, in other words, the city people say, nice product, we just don't have the money, it's not right for us at this time, we'll talk to you again in 3 years or whatever, by which time the technology, of course, would be 3 years obsolete, but that's beside the point. Then there's no reason to register as a lobbyist. And so then what we say is that what triggers it is once the city people become interested and they want to take it to the next level, then at that point, the registration is really triggered. And then at that point, the main city contact for the company ought to call us and register.
In the process of doing the discussion or doing the dance for an existing RFP, RFQ, when somebody is trying to influence a city official regarding their viability to, receive that RFP, RFQ, what's allowed? What's that person allowed to do? Can you
All right, now.
Lunch?
Okay.
Can you go to ball games?
That's a very good question.
Football games?
Well, the answer, if it's the Department of Aviation, is no gifts, okay? Now, whether, lunch is a gift, unless the city people pay their own way, okay? Now, what you raise is an interesting question. Let's say it's a sporting event and the city person pays his or her own way. Mm-hmm. That could be a very complex issue when you talk about face value of tickets, and maybe it's a playoff game. Let's hope it's a playoff game for one of our baseball teams, or maybe it's a playoff game for the Bears or the Bulls. Well, everybody knows this gets into an issue that it's a hot issue ethics-wide across the country. Is how do you value the ability to buy a ticket at face value? That itself, that access to be able to buy a playoff ticket at face value is worth a lot of money. All you have to do is go on eBay and you see that people are out there donating vital organs for it's a crazy world. They'll sell their vital organs for for a playoff ticket. That's kind of an open issue. And so what I would say is, in order to avoid us getting into that issue, I would say that lunches, as long as everybody pays their own way, we don't consider those to be gifts. That's the way business is done. The same thing would be true of golf, as long as everybody pays their own way. They pay greens fees, they pay food, they pay drink. Everybody pays their own way, and no gift, nothing is exchanged in terms of one person paying for another, then we do not interpret that as gifts.
So if you're in a group, basically, and there's only one city employee, he'd have to pay his.
That's correct.
Everybody else gets a free meal.
Well, now you're getting into. No, wait a minute. No, I didn't say that. Because it depends on. Now you're getting into the office's gift policy. Okay.
All right.
So, and that's something that you'd have to take up with Ellen.
Okay, fine.
Okay. So I wouldn't say everybody else gets a free meal. Probably the best thing to do is that everybody pays their own way. If you're dealing with a no gift policy, that would be my recommendation.
That's a business lunch.
Yeah.
Basically, it should be everybody pays.
That's right. Everybody pays their own. That would be my recommendation here.
Now, if it's perceived as something personal, some type of personal event.
Well, in other words, it's a gift, is what you're really saying. Even a lunch is a gift. Even a cup of Starbucks coffee that's worth, whatever it is, anywhere from $2.25 to $6.25, that's a gift as well. Okay? So as long as everybody pays their own way, then there's nothing in our ordinance that would prohibit social activities like that, as long as no value is given from one to another. I want to talk about a couple of restrictions that are imposed upon city officials and city employees that all of you as vendors, all of you who are vendors and contractors ought to be aware of. If, for example, you hire city officials or city employees to do part-time work for you on weekends. Or you may have owners, hopefully you don't, but you may have owners that are city officials or city employees. What are the restrictions? Well, the first restriction is one that the video talks about, which is the money for advice provision, which says that no city official or city employee may be compensated or receive anything of value in exchange for giving advice or assistance on matters that relate to city business. Now, on one hand, that's an anti-bribery provision. But if bribery were involved, I can assure you that the Board of Ethics would be last in a line of agencies that were looking at the situation. But what it really is, from the standpoint of a conflicts of interest agency, is that what it says is that city officials and city employees cannot, so to speak, double dip. And they can't be compensated by a third party, a company, for example, an outside employer that they work for on weekends, for example, to do the same thing that the city already pays them to do. So that means that if those of you who are vendors or work for vendors or contractors, if you have city employees on your payroll and they work for you on weekends, obviously they work for you on their off time, they can't be doing things for you that are related to their city job. Okay, that's what this amounts to. The second provision here is the conflict of interest provision. In a real sense, the entire ethics ordinance and our entire agency is about conflicts of interest. But the term conflict of interest actually has a specific, relatively narrow meaning in our law. And what it means is that city officials and city employees cannot make or influence decisions that affect or benefit persons or matters in which they have an economic interest. What it comes down to is that if you have city employees on your payroll, that in their city jobs they cannot make or try to influence any decisions that would affect your company. Now, that seems obvious enough. The most common way that we see conflict of interest questions are when city officials and city employees have outside employment, because when they have outside employment, they have an economic interest in their outside employer, and it means that their outside employer can have business with the city. They have to stay out of it. In other words, they have to, the legal term here is they have to recuse themselves. They have to stay out of the decision-making process absolutely and completely. So, and if those rules are abided by, then there's no conflict of interest. The other provision I want to talk about is one that the video mentions a little bit briefly, but it's an important prohibition. And this is the financial interest in city business prohibition. What this says is that no city official or city employee may have a financial interest in any city contract or city work or city business. It means that no city official or city employee can have a $5,000 or more ownership interest in a city contract. How do we figure that out? You take the gross amount of the city contract or the gross amount of the combination of city contracts that a company has at any one time and multiply it by the ownership percentage that the city official or city employee has in the company. And if that together yields a figure of $5,000 or more, then it's a violation of the law. Example. Let's say that I own a computer supply company. I'm the executive director of the Board of Ethics, and let's say that I've received an exemption from the city's, from the mayor's office, pursuant to executive order, that I can have outside employment. So I own this company, and my company's not even located in the city. My company's located out in the northwest suburbs. It's out in Arlington Heights, and I have a partner. And my partner's name is Adam. So we're A&B Computer Supply Company. And my partner's not a city official or city employee. And my partner hears that the city's Department of Information and Technology, DOIT, is in short supply of a particular type of connector. And my partner has just received a shipment of 100,000 of these little plastic connectors from Singapore, and they're worth 50 cents a piece. And the city needs 50,000 of them. So it's a $25,000 contract, if my math is correct. Now, my partner says to me, Steve, I know you work for the city. I know this is going to be a problem for you if you work on this contract. Let me take care of all the bidding, and I'll talk with the people that do it. And if we ink the contract, you won't even know about it until it comes time for us to split our quarterly profits and our quarterly losses. Well, lo and behold, once my partner inks that contract with the city of Chicago, the contract is in violation of the law, and so am I. Why? Because you take my 50% ownership interest in this firm. And whether this firm is a corporation or limited liability company or a partnership or sub-S corp, whatever the tax and legal structure of the entity is irrelevant. I'm a 50% owner, and we share profits and losses 50-50. I'm an equal partner. I'm in violation of the law because now I have a $12,500 interest in this $25,000 city contract. Now, we may try to argue that, well, after we pay staff, and there's this depreciation, and there's this tax, and there's that tax, blah, 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 blah. It's actually worth less than $5,000 to each of the partners. No, Board of Ethics won't buy it because it would open up all manner of creative Enron-type accounting. It is simply the gross or aggregate amount of the city contracts multiplied by the ownership percentage that the city employee or official has in the company or in the entity. If it yields a figure of $5,000 or more, it's a violation, pure and simple. And that contract would be voidable by the city. Last thing I want to talk about with respect to these kinds of restrictions are representation of other persons. This really applies to those of you who are city employees or city officials. There are no city officials by our definition in the office. Everybody here is a city employee or a city contractor or city vendor. City employees cannot act as a spokesperson for any third party before any city department or city agency, unless they're doing their job. Now that means, I mentioned before that we get a lot of questions every year about, from city officials or city employees who would like to serve as on the board of directors of a not-for-profit, of a social service organization, a 501c3. Not prohibited by law, but it's just like it's a tightrope that the city person has to walk on, and there are certain restrictions. The key restriction is that even if it's a not-for-profit and they're not getting paid, it still applies. They can't act as a spokesperson for that outside entity before any other city department. So they can't pick up the phone and call their buddy in the Department of Family and Support Services and say, hey, I'm a director of this organization. It's a really good organization. They deserve that $10,000 grant. Please consider them. Can't do that. That's representation. They cannot sign documents that are submitted to the city. So if it's a grant application, if it's a contract application, an RFP, an RFQ, a modification document, a service order under a DUR contract, whatever it is, the city official or the city employee cannot sign that document on behalf of a third party. Now they can do their city job. So if their city job requires them to represent third parties before their department or other departments, there's no restriction. They just cannot act on behalf of a third party in any city agency unless they're doing their city job. And that's true whether they're paid or they're not paid, whether it's Boeing or it's a little mom and pop or it's a not-for-profit organization. It doesn't really matter. So that's the representation provision. What I want to talk about now are the restrictions on hiring city employees after they leave the city, or for those of you who are city employees, what are known as the revolving door or the post-employment provisions, okay? What it says is that for 1 year after he or she leaves the city, a former city employee or official cannot assist a new employer or a new client or represent a new employer or a new client on a business transaction that involves the city. So that's test number one. Is it a business transaction that involves the city? If they were personally and substantially involved, that's the second part, in the subject matter of that business transaction. So you got three things. First, it's got to be a transaction with the city. Second, they have to have been personally and substantially involved in the subject matter of that transaction at any point during their city career. Okay? That's quite complicated. What's subject matter? Well, subject matter is a really funny beast. I've been at this for over 15 years, and subject matter varies from case to case to case. The only general rule I can say is the higher up a city official or city employees in terms of responsibility, the wider swath of subject matters he or she has been involved in their city career. It may mean certain aviation matters for 1 year. It may be any dealings out at either of the airports or both airports for 1 year. It may be a certain type of transaction for 1 year. It may be just one particular transaction for 1 year. It really just depends on the facts. Now, I want to stress one key thing about this, and that is that the law does not say that a former city employee or official cannot work for any particular company. A former city official or city employee can work for any company that he or she wishes to work for. Okay, that's not the way the provision works. The way the provision and the prohibition works is that it is a transaction-based or project-based or contract-based prohibition. And likewise, in other words, a person may have to be screened off from working on certain matters, either for a year or for 3 years or for 4 years, depending on the life of a contract. But they can still work for the company, and the key is that the company can still have those city dealings, provided there is an appropriate screen in place. What I want to talk about kind of last is campaign financing. in elections and campaign contributions. Let me talk first about the city's laws. The city has a campaign financing ordinance that has been in effect since 1987. What it does is it limits at $1,500 contributions that can be made to any of the elected officials of the city of Chicago or any of their official election committees in a reporting year. And a reporting year, for reasons that I've never been able to quite figure out, is a July 1st year, July 1st to June 30 year. It's not a calendar year. If you're a company that does business with the city, in other words, if you have $10,000 or more in business with the city of Chicago or any of its sister agencies like the Park District, like the Chicago Transit Authority, like the Chicago Public Schools or McPeer, then your company is limited to $1,500 in political contributions to any of the 53 elected city officials in any July 1st to June 30th year. That's the campaign financing ordinance in a nutshell. One key caveat here is that by executive order passed in 2005, the mayor's political committee does not accept any contributions from persons that are doing business with the city or their employees or their officers or their spouses or their domestic partners, and those people are prohibited from making contributions to the mayor's campaign. But as to the other 52 elected officials of the city, the 50 aldermen, now 49, but there'll be an appointment eventually, and the clerk and the treasurer, those limitations apply. Okay, so if you're doing business with the city, and a lot of you in this room either are employees of persons doing business with the city or are owners of persons doing business with the city, then those campaign contributions are applicable. Now, what if you are an employee of a company that's doing business with the city and you want to make an additional contribution? Let's say the company makes its $1,500 contribution in January. On January 1st, they make a contribution to Alderman X. You want to make an additional contribution to Alderman X. Can you do it? Is your contribution combined with the company's $1,500 contribution so that it might make you in violation of the law? The answer is, like so many things in the law, it depends. What does it depend on? It depends on whether you're reimbursed. Okay? If you're reimbursed for that contribution, either directly or indirectly through bonuses, through additional compensation, whatever it is, indirectly, then your contribution is combined with the company's, and it would have to be under $1,500 together. On the other hand, if you're not reimbursed in any way, shape, or form, then you can make an additional contribution. If your company's already maxed out at the $1,500 level, you can make an additional contribution. It's a fact-based question. And most of the campaign financing laws in this country have provisions like that. So it's a matter of, it would involve a technical investigation that would involve forensic accounting, et cetera. You have to figure out whether a person was indirectly reimbursed. Okay? But that's what the law says. Okay? That also applies to owners of companies. Owners of companies, as long as they are not, or shareholders of companies, as long as they are not reimbursed by the company, or they are not themselves individually doing business with the city, or are not a registered lobbyist. These contribution limitations are also imposed upon registered lobbyists. They are also imposed upon persons who are seeking to do business with the city. Seeking to do business with the city means that they have bid on contracts which have not yet been awarded, which, if awarded, would be $10,000 or more in a 12-month period. Or it means that they've had matters pending before the city council involving zoning, involving contract matters, involving bond matters. Certain matters are exempted. For example, the homeowner who wishes calls the alderman, something has to go before the city council with respect to an awning on their house. That's exempted. A handicap sticker, that's exempted. But any real estate matter, any matter that involves a city contract, any matter that involves bond or tax increment financing that goes before city council, any person who has those matters is subject to this $1,500 a year contribution limitation. Now, what are the things that the state law adds? Well, the state law adds, if it's not a state law yet, I should say. What does the potential state law add to it? One of the things that it will do, as I read it, and as I think it's a correct reading, is that natural persons, and a natural person is a lawyer's way of saying a bodily human being as opposed to a company, Any of us, for example, would be limited to $5,000 in contributions in any calendar year to any elected official in the state of Illinois, not of the state of Illinois, but in the state of Illinois, which would include the 53 elected city officials, $5,000 in a calendar year. Companies would be limited to $10,000 in contributions in a calendar year. Now, you realize that if you're a company, the city's limitations are already stricter. Okay, so you'd be subject to the stricter limitations of the city's city's campaign financing ordinance, not the state law. And likewise, for the first time ever, labor unions are covered. There's a contribution limitation that will be imposed upon labor unions. There will be contribution limitations that will be imposed upon PACs, or political action committees, that are formed by companies who themselves might be prohibited under federal law from making contributions, but their employees are not. Well, those employees' PACs, or those company PACs, will now for the first time, or would now for the first time, be subject to campaign contribution limitations. So those are the campaign financing ordinance limitations. One thing also I should say about the city is, what are the penalties if a person exceeds the campaign contribution limitations? Let's say your company gives, inadvertently, whatever, gives $2,000 to Alderman so-and-so, and your company's doing business with the Department of Aviation. Is your contract going to be canceled? Are you going to be sued? Are you going to have to pay a big penalty? The answer is, under the city's law, that the remedy that we have is to require you to receive a reimbursement from that elected official. So that's our campaign contribution limitations. And yes, I'm sorry. Here we go.
This isn't for campaign contributions, though.
That's okay.
Am I right to assume that acceptance of an invitation to a contractor or a lobbyist holiday party constitutes a gift? And if so, is that now banned by...
Well, my reading is yes. Ellen, if you can, if I want to have my answer confirmed by Ellen.
Wait a minute, you're the attorney here.
Well, I'm the attorney. I would say yes. If it were me, I would advise you that it's banned. The question, if you could repeat it.
Acceptance of an invitation to a holiday party, which is sponsored by either a contractor or a lobbyist, constitutes a gift, and if so, is that now banned for all Department of Aviation and NYPD employees?
Not banned. You can go. You need to pay your own way.
What about a labor union?
Doesn't matter. If you'd like to go,
So what constitutes paying your own way, though?
find out from the organization what the average cost is, and if it's $35, write them a check for $35.
That's right. And that's
certainly you can go. We're not saying you can't. You just can't accept a gift. And so that invitation would constitute a gift. Pay your own way. Same with Cubs tickets, anything else. Pay your own way.
Does everybody? If I could get everybody's attention, this is a very important point. I know that the question was up at the front, but those of you who are standing in the back need to know as well. The question was, if a person sitting in this room who's subject to the department's gift ban is invited to a lobbyist's holiday party, a party, the air show's coming up in a month and a half. There'll be lots of parties that have nice views of the air show. If you're invited, can you go? Is that a gift? The answer is, it is a gift, but you can pay your own way. Okay? Now, if you don't know what the value is, you'll have to ask, and they'll give you a value. So that's what it really comes down to. If you pay your own way, it's not a gift. So now let me see if there are any other questions. If not, I'm going to conclude here by saying that, number one, I very much appreciate the opportunity to come out. Number two, my phone number, my agency's phone number, is on the materials that you have. Our email addresses as well. You pick up the phone, you call us. It's confidential, and you will get advice from us. And I encourage you to call us with whatever questions you have, because I've been in this business a long time, and there's no such thing as a stupid question. Okay? I thank you very much for your attention.